The Fair Housing Act of 1968 prohibits the discrimination against protected classes in the housing market. If you're hoping to ace your real estate exam and become a real estate pro, you'll need to understand the Fair Housing Act and its amendments. Luckily, you've come to the right place to educate yourself on this topic. Hello everybody, it's Zach here from RealEstateLicenseWizard.com, and today we're going over the Fair Housing Act and its amendments. Let's get started. So what is the Fair Housing Act of 1968? Well, the Fair Housing Act of 1968 protects buyers and renters from discrimination when looking for housing. It's also known as Title VIII of the Civil Rights Act. The FHA essentially prohibits real estate professionals from treating individuals with protected classes unequally. Who does the Fair Housing Act of 1968 protect? Well, there's 5 protected classes covered in the Federal Fair Housing Act of 1968. There's 1 race, 2 color, 3 national origin, 4 religion, and then 5 sex or sexual orientation and gender identity, which was later added. So let's take a closer look at each protected class to understand how the FHA defends them. So fair housing laws make it clear that real estate professionals and housing providers cannot discriminate based on race. For example, if a real estate agent tells a minority that a house has been sold but continues showing the home to other people, this could indicate racial discrimination. The Fair Housing Act also states that everyone, regardless of their skin color, has the right to fair housing and housing opportunities. If a landlord only rents out homes to white tenants, this could indicate that they are discriminating against renters based on skin color. Housing providers also cannot discriminate against home buyers and renters based on their ancestry, culture, and national origin. If a real estate agent refers to work with buyers from a particular country or region, they can be considered discriminating, obviously, against that protected class. Now, according to the FHA, home buyers should also have access to housing opportunities regardless of their religious beliefs. If a real estate agent were to steer a Muslim buyer away from a white neighborhood, this could be a violation of the Fair Housing Act. And then, of course, sex is another protected class under FHA, which includes sexual orientation and gender identity. This means, housing providers cannot treat same-sex couples or transgender individuals differently than they would anyone else. So what's the history behind this? Well, to fully understand the significance of this act, we need to understand the history leading up to it. You need to understand that the Civil Rights Act of 1964 and 66 really paved the way for the Fair Housing Act of 1968. At that time, racism and segregation was still rampant in the United States, and that's why the Civil Rights Act of 1964 was designed to prohibit discrimination and segregation in public places. The protected characteristics under the Civil Rights Act included race, color, religion, sex, national origin, paving the way for the Fair Housing Act 4 years later. The key takeaway here is that you need to understand that the Civil Rights Act of 1966 set an important precedent, which then led to the Fair Housing Act. Now, what types of housing does the Fair Housing Act cover? Well, the Fair Housing Act protects against most housing types. I'll put a list on the screen. We've got single-family homes, multifamily homes, apartments, condos, mobile homes, and nursing homes. Essentially, if a property constitutes a dwelling or place of residence, there's a strong chance that interested buyers and renters are protected under the FHA. So what does the Fair Housing Act not protect? Well, while the Fair Housing Act and its amendments cover a lot of ground, it's important to note that this act doesn't cover all housing types. So, for example, apartment buildings with less than 5 units, single-family housing sold without a real estate agent, housing for religious organizations, hotels and motels, private clubs, things like that. And it's obviously important to note as well that the Federal Fair Housing Act does not consider the following attributes to be protected characteristics: age, citizenship, occupation, source of income, marital status, and a few others. Now, it's worth mentioning that fair housing laws vary from state to state. So it's essential that you are aware of your own state's fair housing laws. Remember, this is the Federal Fair Housing Act. Most states have their own fair housing law in addition to the Federal Fair Housing Law, which can add protected classes, things like that. So let's talk about an example of a Fair Housing Act violation. So real estate professionals must understand which behaviors obviously would violate the Fair Housing Act. So we've compiled a list, and I'll put them on the screen for you. So I'll just go over a couple of these: refusing to show minorities houses in certain neighborhoods, harassing a home buyer because of their religious beliefs, refusing to repair a tenant's unit because of their sexuality, things like that. Now, there's penalties for violating the Fair Housing Act: $16,000 for a first-time violation, $37,500 for a previous violation if it's occurred within the last 5 years, and then $65,000 if 2 previous violations have occurred within the last 7 years. Now, in cases where home providers use force or even threat violence or something that might constitute fair housing law violations, the penalties can be even more serious, including possible jail time. So where did the Fair Housing Act of 1968 fall short? While this act played a significant role in the fight for fair housing, it still had a long way to go. For example, the FHA failed to protect all vulnerable categories of home buyers. The FHA was also rarely enforced by the necessary departments, so it lacked effectiveness and strength. As a result, the Fair Housing Act of 1968 failed to eradicate housing discrimination. Luckily, the Fair Housing Amendments Act came along in 1988 to strengthen the FHA and added 2 additional groups to its protections. So the first one would be familiar status, and the second one would be disabilities. Those are the 2 protected classes it added. For example, a landlord, before then could try to charge tenants extra for having young children. That would now constitute a violation. After 1988, it now would violate the FHA. And then obviously the disability thing, for example, if a landlord is selling apartments that are not accessible to renters in wheelchairs, that could be considered a violation until reasonable accommodations are made. So how can real estate professionals fight housing discrimination? Well, as a future real estate professional, it's your responsibility to combat housing discrimination and ensure equal housing opportunities for all. I'm going to put a quick list of things on the screen, but essentially the most important thing to do is treat all your clients equally. It's that simple. You need to be treating everyone equally and fairly. So what do you need to know for the real estate exam? Well, the Fair Housing Act of 1968 protects buyers and renters from discrimination when looking for housing. This protected 5 classes. 20 years later, the Fair Housing Amendments Act of 1988 came along, which strengthened the FHA, the original act, and added 2 additional groups to its protection. Know this and your specific protected classes, and you'll be good to go come exam day. For more videos on fair housing and even antitrust laws, click the video here and click here to subscribe. Thank you so much for watching. Until next time, see you guys. Bye.